in the body of the charge. It said one of the misrepresentations was that the said 9 service stations were encumbered to the ministry. The usage of that phrase, encumbered. The first point is that term is not in the agreement between the NECON and the Ministry of Defense. It is introduced by the state in the charge sheet and the investigating officer in contravention of the integration rule as far as law of evidence is concerned, parallel evidence rule, your ladyship. But more problematic, apart from the concession by the investigating officer that there was no misrepresentation prior to the 15th of July, there was complete misunderstanding both by the state council with respect and the investigating officer. As that term, they were not entitled to introduce a term that is not in the agreement between NECON and Ministry of Defense, but their inclusion of that term offends the law, and I wish to end up a judgment on that issue. Can I have the my lady, I hand up an extract from a judgment of Rain N.O. versus Glacier, 1984, Volume 4, SA 863. The good thing, my lady, is that this judgment was from the former appellate division in South Africa, and in terms of our case law, those judgments prior to 1990 of the former appellate division, unless upset by subsequent judgments in Namibia, are binding on Namibia. May I invite the court at the bottom of page 872, the court referring to Chief Justice Innes in a judgment delivered in early 19th century. The court said encumbrance means a real burden on the land, a portion of dominion parted with by the owner. If it does not mean any reference to the land in a contract, giving a mere action in personam into the contracting party with respect. What it means is that when you are talking in the context of to encumber, it's not personal or contractual rights, even in relation to land. For instance, if you say, I am selling you my land and you are taking me to court for breach of contract. Encumbrance means more than that. You part with your, in other words, you subject your right of dominion to, so that that right is respected by, not only by the party, by everybody. For instance, if you take out a bond, then the land is encumbered. My lady, it's not a personal contractual right. Therefore, to move to the last issue, first of all, the state case falls flat on the basis that encumbrance is an alien introduction by the state, a strange one, a curious one, actually.
If you say the state's case is falling flat, you are meaning count 32 there?
Yes, on the front, where they sought to introduce a term themselves, not appearing in the contract between NECON and Ministry of Defense. Yes. But even if it appeared, yes, it can only work if encumbrance in that respect meant the asset that were owned by NECON were encumbered, so that that right of the Ministry of Defense, as far as encumbrance is concerned, binds everybody. Your ladyship, you cannot go to the ministry and seek to get any right because there is a registered encumbrance of the right, my lady. So with respect, I think the state in panic to try and justify why people were arrested find itself laying its hands to any term they wanted close to their hands.
Are you saying it's a defect in the charge sheet?
Because in law there are several legally speaking,
Yes.
it's an impossibility.
Okay.
Because the term is not in their contract.
Yes.
Parole evidence rule is against them. Integration rule is against them. Secondly, they, with respect to misunderstood and misconstrued what it means. Remember in cross-examination, my colleague will have to defend his mispraised cross-examination of my client. He was saying that, yeah, these assets were encumbered because of 15 years. 15 years has nothing to do. It's a contractual personal right that my client must continue supplying Ministry of Defense and ECON. It's a contractual personal right. And it was never disturbed because the understanding between Namcor and ECON is that you continue getting product from us and supply Ministry of Defense, and we benefit because we have exclusivity. So simple, my lady. And the last one that I...
No, I want to pursue this.
Yes,
I've read the arguments by the respondent
yes.
concerning the so-called defects, or if there are any defects in the charge sheet. He says that that's irrelevant.
That?
It would be irrelevant at this stage, at bail stage. Because remember, he referred to this words that the appellants have said about the charges, that they are weak, they are half-cooked, they are chaotic, they are pathetic. And he's saying that even if the charges are weak, they are half-cooked, chaotic, and pathetic, it does not affect the strength of the state's case, which is a bail consideration.
I didn't want to kill a case this morning so early, but I decided, because you asked the question, to do it just right now with reference to a case law.
Yes, because I need to pursue that. You are going to give him an opportunity. Of course, he's going to have his version, but now you are saying, no, you know, it's a defect. This charge does not even stand up from anywhere.
Yes.
But he says that's irrelevant for purposes of time.
Three big and very big, reasons why that will not fly. The first is that it's common cause, and we stated in the introduction of our heads of argument that on the appearance of on the 10th of July, the apparent complaint that the charges were not clear. It is there, it is on record, my lady. I think it is even in the typed up court proceedings. My lady, I will give you, when I reply, I will give you a page number. That means that we wanted the state to put its house in order, which was seemingly not in order as far as the charges are concerned. And fairly so, remember, we engaged the state at the time of a bail application, the state having chosen to tell us that we will be opposing bail on the basis of this allegation. We say they are not clear, go get an opportunity, make sure when the bail application took place, I think it's a week or 2 weeks thereafter. And they were given that opportunity by a magistrate doing justice. Remember, we were saying we want bail application to be heard on a Monday. But the magistrate, to do justice between men and men, the magistrate gave them an opportunity, and they went to their offices, and we understood that we have done our work. These are the charges between the parties. On that basis, they are stopped from complaining. They must lay in the bed they made. They cannot escape on an apparent division. In the magistrate court, that was not the argument. In the magistrate court, they were not saying that, except the investigating officer who started telling us medical things that the prosecutor had to be called from sick leave. So that is the first reason. Fairness, we asked for particulars, and we were given particulars, and they are bound by the particulars. The second reason is unnamed judgment. In the unnamed judgment, Justice Ndo And he referred to, because its fairness extend to bail inquiry, particularly because it has something to do with liberty of an individual who is still presumed to be innocent. Said, if you give, we decide your case based on the charge before the High Court. Now remember that case, the ratio that's it 100. One of the ratio is, can you dispose of a bail application with reference to the charge, if a charge is back? In the High Court before Justice Law, which is binding and has never been upset, I represented Mr. Unegu, and we won basically on a charge of rape, because we stated that the allegations of a concept of rape in our law, the elements in the section 2, subsection 1 of the Combating of Rape Act are very clear that it is an insertion of any part in the vagina, in anus, and so forth. And the judge, though, made it clear. If the state simply went to court and told the complainant, say that we had sex, remember there is a Katuta judgment, my lady, again, I argued it before Justice Marit and Justice Silungwe, where they said it's not enough in a rape matter for a judge and for a state to rely on allegations of sex, because that does not conform to the element of the offense. So the state cannot cry, and there is an obstacle because the judgment of no is against them. Were they lying to us when they say we have revised the charges? Here they are. We are entitled to rely on the charges and to stop them from running away in panic. They can't. They are bound. The last one is then the judgment I said it will kill their case, is that we have, from 1990, the court, unlike before independence, relying more on positivism. Yes. Its function is now more broader, both in trials and bail application. And it was stated in a very important judgment where the conviction was set aside just because the lawyer was incompetent. He didn't know how to cross-examine, and some questions actually almost came close to some questions I saw in cross-examination before this magistrate, but I don't know. The case is S versus Chabedi. It's 2004, volume 1. SACR 477. Yes. 477, and my lady, for your comfort, this judgment was followed in this court in S versus Andima. 2010, volume 2, page 477. Now, the court from paragraph D, and this is important, and it addressed Justice Christian questions on regarding my grounds yesterday, so that it says.
You said which paragraph?
From D to the bottom. Okay. In the present constitutional era, it is one of the functions of a court of appeal, hearing a criminal appeal to inquire, here it's a bail inquiry, into the fairness of the trial and to ensure that the accused's right to a fair trial is fulfilled. Particularly where, as in the present case, an irregularity appear ex facto. The right to a fair trial confirmed by that provision is broader than the list of specific rights paragraph 8J of subsection provides. It embraces a concept of substantive fairness, which is not to be equated with what might have passed muster in our criminal court before Constitution came into force. And then it referred to the other judgment where it was saying whether there has been any irregularity, in this case is a misdirection, it's the same thing, or illegality, that is a departure from the formality, rules, and principles of procedure according to which our law requires criminal trial to be initiated or conducted. So in other words, my lady, to also to complete your question, if we ask before court, give us something more concise so that we prepare for bail inquiry, and the state with its muscles and with its resources and a battery, and in fact, I will not call it a battery of lawyers. There were so many prosecutors, some in the gallery when we met the state council. It was a forest of lawyers and police officers assisting the state in this case. So when they go and sit in a huge room and they frame the charges and say, here it is, how can they cry today that no, Mr. Namcor may be correct. They are incompetent, but we will amend them. So you are lying to us, they can't. The last one is then set off. With the greatest respect, my lady, I continue asking, did we actually have court in the magistrate court? Court, a judicial tribunal, a judicial hearing, did we have? The big answer is that no, we actually did not have. If we had one that was not impartial and one that was not competent, with greatest respect. And competence is not because there are people who come around listing PhD, whatever. I'm not talking about to take it off that the magistrate has a law degree from UNAP, where I also studied. I'm talking about whether the magistrate was competent enough to discharge and undertake an inquiry such as this to dispense justice in accordance with the law, with no prejudices, my lady, to anyone, and no fear. My lady, Justice Christian, as a young acting judge, I have to take one of your judgments in malicious prosecution to the Supreme Court in Mahupiro versus Mahupiro, and you wrote a very good judgment on one point. It was your judgment that found in Namibia first that a prosecution can be legitimate from the beginning, but in between, from a certain date, when it becomes clear that there is no evidence against an accused person, the state has the duty to stop prosecution. That matter, that principle that you wrote about, was not upsetting the Supreme Court. The judgment was set aside, but that principle was confirmed. But you, at that point, you were an acting judge, but it was a high treason matter, where allegedly public interest people died in Katima. So a judge or a presiding officer must not be there to buy faces. So let's see how, with respect, if I was in a cooker shop, I would say the court we got was buying faces with respect. I want to take your ladyship to the findings of the court on set-off, where the court just took the investigating officers.
Is this your second point you are addressing?
Yeah, set-off.
Is it your second point
yes,
you are addressing?
Yes.
Okay.
And it's very important.
Yes.
It is in the judgment, my lady, if you go to paragraph 52 and 53 of the judgment, I think it's page 4688, if I...
4688.
Yeah, paragraph 52, my lady.
Yes.
And I don't like this flavor as far as program. Paragraph 52 and 53. Yes.
So it's 466, 4688 and 4689.
Yes. My lady, you will see that is from page, I'm looking for the paragraph, my lady, that spoke of the fact that he found that the Enecon paid with.
Enecon?
My colleague is...
It's paragraph 53.
Oh, yes. Yes, it's in the middle of 53. And it is many, let me just address it, how
Yes.
it doesn't even begin to fly. First of all, is a complete misunderstanding. The investigating officer thought it is inappropriate to ask him to say, look, you are investigating a matter that is in a commercial context, where you ever trained on law of contract or commercial, just to have a rudimentary and basic knowledge so that you don't start running around just arresting people because you don't understand. It's not a bad question. We asked that question because in a commercial. So now the judge say, the magistrate say, no, there was no payment. That is Namcor's money. Ignoring that the agreement was found, even him found that the agreement was legitimate. In some cases, the magistrate also found that the agreement had to be complied to, my lady, in some part of his judgment.
I'm not following. Are we now speaking about the 35 million?
Yes, because it's basically a setup.
Yes. Okay.
Remember, a setup is, my lady, is
Yes.
legally speaking,
Yes.
is when two parties to an agreement have mutual debts to one another.
Yes.
And the most important thing, and this is a case I want to refer to, which the magistrate with respect, we didn't want to burden because we assumed the magistrate knows these basics, but I think we took a risk by not giving him the basics. May I hand up a judgment of union? Yes. Just end up. We cannot find some copy, but I can read it out then. It's a 1926 judgment, my lady. That case of Schroep versus Union government.
Yes.
And again, everybody who has gone to a good varsity, not in Afghanistan or wherever, but in South Africa, Namibia, good knows who is Chief Justice Innes. And at the bottom of page 289, that judgment says where it starts after England, my lady Justice Christian, I think what we're talking about. It is a recognized principle of common law, referring to settle, my lady.
Yes.
When two parties are mutually indebted to each other, both debts being liquidated and fully due, then the doctrine of compensation comes into operation. The one debt extinguishes the other pro tanto, as effectually as if payment has been made. Should one of the creditors then go on deposit, then it goes on the other. Set-off happens as a matter of law. When you pay, you are just effectuating it. So in other words, what happens here, it was open to Namcor actually, if they wanted, because remember their legal department is the one that drafted the agreement. It was open to them to say, Namcor, you owe us over 53 million. We are buying interest title and so forth for 53 million. We could actually take everything. It was open to Namcor to say that. But the magistrate will not have a right to say, because it happens ex-lege. It is nothing need to be said. If you owe me 20,000, I owe you 10,000. It's a question of law. So there is therefore no concept of the magistrate to say, Namcor paid with Namcor's money, because if they wanted Namcor, they could have taken the money and say, in terms of this agreement, the 53 million is due to you. We are not going to pay you. But because they want a relationship, remember Namcor was suffering from this commercial attachment issue, wanting to be after my client's good contract. They want to be a future supplier to MOD. So they agreed that only 35 million. So it is wrong, given that Whether it is an agreement, my lady, it is an agreement or not, by way of settle, that 35 million would in any way have been paid to Namcor, and that is what I wanted to address. And my colleague, with respect, his submission misled the court altogether. We would not have been here. The accused person should never have been refused bail. Those are my submissions.
Thank you, Mr. Namanji.
My junior just oh, very good. Yes. My junior is just referring in page 148.
Yes.
There are two issues that maybe so that we don't come back. The issue of 480 million is on top. Your ladyship, you can see that big number. That is on the first day we were hit with this 480. But at the bottom, when Mr. Namanja is my lady on the left-hand side,
Yes.
you would see that from paragraph where we are talking about we are going to be provided a complete indictment at 4:15. If you look at the record when we started bail application, we were never provided, we complained why the court order was not complied with. So the state provided itself with more time to work on the charges.
Yes.
And an advocate from the High Court was placed, and a very good friend of mine, Advocate Rirong, was brought in to be with Advocate Hinda, so that the charges are proper, my lady. So the complaint is there. So, and I'm addressing the issue of Justice Christian to say, apparently in their heads are saying, yeah, let's not talk about that. They were given an opportunity to fix, and they promised court that they had fixed it, my lady.
Thank you, Mr. Namanji. Mr. Lelongwe. Oh, Mr. Simunye.
My apologies before my colleague Mr. Lelongwe takes the floor. I promised the court yesterday there's a case on the issue of the 14 days
Yes.
appeal from the magistrate court to the High Court. I did get the case. I begged you to hand up the case. But it's basically your ladyship. It's the case of Zacchaeus Cornelius versus the suit, CA 103 for 2009. The appropriate section of that is page 5. It's on page 5. It starts on page 5, but going to page 6. But it's talking about helpful guidelines to judicial officers when explaining the right to appeal. So if your ladyship turn to page 6, on top of page 6, where it explains should lodge the notice of appeal with the clerk of the court within 14 days from the date of conviction and sentencing. So it's the issue of where the 14 days emanates from. So this case, the judgment delivered by Liebenberg and Tomasi J. Axel explained that issue of 14 days.
But does it help us regarding the issue that was raised? Because it's the very aspect that we've spoken about. I think Mr. Casper is referring to a situation where Rule 67 deals with convicted accused persons. And this is what you are addressing. What is this judgment is addressing? Now we are speaking about a bail appeal done in terms of Section 65 of the Criminal Procedure Act. His take was that Rule 67 should not apply because in this case you don't have accused that are convicted. You have somebody that has got a pending case against them who applied for bail, whose bail has been refused. And there is no rule, except for him highlighting Rule 51 of the Magistrates Court rules that deals with civil appeals, that says what the timeline is for a bail appeal to be filed. What we know is, that was his argument, is that bail is not civil, it's not criminal, it's in a class of its own. So if we use Rule 67, because it has been practiced, it will be 14 days. Then if you don't comply in filing the notice of appeal within 14 days, you should file an application for condonation. His take is, no, it would be best, because it's an application, that it be dealt with under the civil rules in the Magistrates Court Act. That is Rule 51, which will bring you to 21 days late. Then you can file a condonation.
In this,
Yes.
but as your ladyship is saying,
Yes.
in practice,
Yes.
this has been adopted in practice. The 14 days emanates from there. For the sake of confirming where the 14-day period is coming from and having a case that is explaining that, it's for that reason that I brought up this case.
Okay.
Where it's explained the 14-day period.
Thank you.
Thank you.
We'll consider it.
We are revisiting the arguments, it seems, this morning.
Argue this case on my behalf, and I would be remiss if I
Yes,
said
yes, yes.
put you in that
Yeah.
predicament.
Yeah.
The simple point I made, and in fact, this authority is not good proposition for the point I made. Number one, it deals with an instance of a convicted person,
Yes.
and it does not concern itself with a bail appeal. And in fact, where the 14 days are birthed in any event is again the misplaced reliance on Rule 67, Sub-Rule 1. But of course, for this instance, it's not misplaced because the court was then concerned with a convicted and sentenced individual. So, court will.
Thank you.
Maybe while I'm on my feet, my lady, just one small aspect. And it speaks to the question you asked, because I get the impression that it troubles you, my lady, in relation to the issue of the charges.
Yes.
Now, my lady, let's accept that's what the situation is. And then, in opposition to bail, the state says to the accused persons, amongst others, why we are opposing bail is because these are serious charges. And then, I mean, it's a strong case that the state has. How do you assess that reality, my ladies, if not on the charges before you?
I have a question for the respondent when he rises.
I'm sure you'll
A
agree
follow-up
with me.
question coming from the question I've posed to Mr. Namanji. And then, when we reply, after he has addressed,
Yes.
I would want us to respond also to that follow-up question I'm
We look
asking.
forward to that, my lady.
Yes.
Thank you. Mr. Lilongwe, unless there's somebody else who wants to say something. Okay, Mr. Lilongwe, I was just reminded it's just before 11, so we will break for tea at 11. But I want you to address us firstly before you start, because it's been raised here that the court gave you everybody an order to use the portal of the ancillary process on the case management system to bring your application for condonation. And yours were not brought through that process, although it was part of the court order, and I think it was explicitly part of the court order. So I want you, if we convene at 11:30, I want you first to just address that, because according to the objections that we received from the appellants, they indicated that they would not like you to then use your heads of arguments in this matter, because it's not properly before court.
This is Mr. Ashudena. Yes, I hear that, my lady.
No, but I think it's a sentiment of court also, because we gave you explicit order. So we would like to know, firstly, why we should hear you on your heads of argument in this matter, or why we should take cognizance of those heads of argument. Because they were not followed, they did not follow the process as set out by the court on our previous appearance. Okay, the court stands down for tea.